Good evening, everybody. And on behalf of the Dauphin County Bar Association, we welcome you to what will be an outstanding program to discuss an important topic. Regardless of your political or social beliefs, the nature of our democracy is a key to who we are as a people, and something that we all should work to protect and defend. It's what has made the United States an example that most of the world has worked to emulate. The BCBA's purpose, the Dauphin County Bar Association's purpose, is to advance the science of jurisprudence, to promote the administration of justice, to encourage legal education, and to promote the continuing legal education for our members, and to uphold the honor and dignity of the bar. Those are a lot of very lawyerly words, which really mean that the DBA is committing to promoting the access to justice and educating the public on the importance of topics such as this, an independent judiciary. I'd like to take a moment, as our immediate past president, to thank a number of our key sponsors. First, Keep Our Republic, who you're going to hear about in just a moment. The Pennsylvania Bar Association, and Matthew Holliday, their executive director, is here. The Pennsylvania Bar Foundation, through its support of a Birdsall grant, also part of the PBA. Widener Law Commonwealth, where we are currently located, and recognize our DCBA president, Fawn Kaler. I'd like to take a moment to thank our planning committee. There are a number of people that helped put this program together. The Honorable Robert Gracie, colleague and friend here on my left, Sarah Lockwood, Jim D'Angelo, Kaylee Ryder, Carolyn Anner, Charlie Lyons, Ari Middleman, and Madison Jorfie, all of which were instrumental in helping put this together. I'd also like to thank our DCBA staff, Patrice Mazanis, Kim Snell-Zarconi, and Bridget Hilbesh, who are in the back there helping people there as people are still coming on in. Now my distinct pleasure to welcome my partner in crime for this program and our program last year, who's helped put these together, the Honorable Robert Gracie, who is not only a member of the PBA and the DCBA, but a member of Keep Our Republic, to give you a little bit about his organization.
Thank you. Thank you, Jonathan, and to our attendees, welcome. On behalf of Keep Our Republic, I'd like to thank Dean Cummings and Widener Commonwealth Law for hosting us this evening and for allowing us to use this great facility. Thanks as well to our partners, the PBA, Pennsylvania Bar Association, in particular the Dauphin County Bar Association, for organizing and planning this event designed to educate and, at the same time, hear from the public on what makes our republic strong and what it takes to keep it. I'd like to take a minute, if I might, to share a little bit about Keep Our Republic. It started in 2020 when a group of former government leaders from around the country came together, guided by the principle that the vitality of America's democracy is strengthened by promoting trust in elections, maintaining a nation of laws, and a government based on constitutional checks and balances. This group, from both major parties, included Governor Tom Ridge, who was instrumental in KOR's launch. The group also includes another Pennsylvania governor, Tom Corbett, who sits on the KOR National Board and chairs its Pennsylvania Advisory Council. In 2024, Governor Corbett asked me to join the Advisory Council, and I committed right away, because I understood the importance of the group's work in underscoring the importance of maintaining the democratic principles on which our country was founded. At our core, we're a civics education organization. We know that Pennsylvanians and people from around the country have questions, and we know that asking questions is part of a thriving democracy. The event tonight is part of a series examining judicial independence and the judicial process. Similar events, with panels featuring a number of retired federal judges, are being held around the country. One was held just last month in Western Pennsylvania with Governor Corbett and retired federal district judge and KOR member Bob Sindrich addressing these important and timely issues. And we're so pleased to have our three distinguished judges here tonight to address them. The retired federal judges on our panel, Judge Andre Davis, most recently a judge of the United States Court of Appeals for the Fourth Circuit, and before then a federal judge and a state judge in the District of Maryland, and Judge Robert Kugler, a retired federal judge from the District of New Jersey. Both are members of the Article III Coalition, an initiative launched by KOR earlier this year. The coalition includes more than 40 retired federal judges appointed by presidents of both political parties going back to Jimmy Carter. And they're speaking up about the need to protect judicial independence. And we're very happy to be joined by my friend and former appellate court colleague, President Judge Emerita Bonnie Ledbetter of the Pennsylvania Commonwealth Court. Importantly for tonight's purposes, Judge Ledbetter serves on the Pennsylvania Supreme Court's Commission on Judicial Independence. This commission was established in 2005, 20 years ago, and was charged with fostering a greater public understanding about the role of the judiciary, explaining the value of an independent judiciary, and illuminating unjust criticism of judges and the judicial system. So as you see, these are not new concerns, and we're happy to have Judge Ledbetter share some views on these concerns from a state court perspective. Now, John, back to you to introduce our moderator.
Before I introduce our moderator and really turn over the program to her to kick us off, I do want to say a little housekeeping, and that is, as you entered tonight, you were given a note card and a pencil. If you didn't get one, just kindly in a moment raise your hand and we'll bring them to you. Because we have some members of the media here, if you have a question that you would like asked the panel, just write it down, hand your note card up. We'll bring you a fresh one, and then we'll kind of pull the questions together as the evening goes on. I'll quietly be walking them down to our moderator just so that you know, so everybody can hear the question and then they're properly recorded. And now I'm going to introduce our moderator today, Asia Tab. Ms. Tab is the host and producer for WITF's The Spark here in Harrisburg. She began her start in radio when she joined legendary radio host producer Doc Christian. She worked closely with Doc in her role on The Gospel Express on WHOV 81 FM and was a host for The Unrestricted Paradise at Paradise FM. Previously, she was an anchor in Shreveport, Louisiana at KTAL KMSS. And as someone who's worked for the government my entire career, it was nice to see that there was somewhere else where there was an alphabet soup, not just my bio. Ms. Tab worked as a multimedia journalist at WHP-TV here in Harrisburg. She got her break into news at KTVO in Iowa, while the 2020 caucuses were gearing up, she followed many candidates through their campaign trail, from Senator Cory Booker to Congressman Tulsi Gabbard to the 46th President of the United States, Joe Biden. She was born and raised in Norfolk, Virginia, and graduated from Old Dominion University in 2018 with a major in communications. I'm going to turn our program over to you. Thank you.
Thank you. And I'm also proud of you for getting my hometown correct. So many people say Norfolk, and that's not how you pronounce it, but thank you so much for that.
I'm glad. Thank you.
Good evening, everyone, and welcome to Widener Law School. I hope you had a great start to your week. Happy Monday, everyone. You have to give me energy. Say good evening. We're going to have a great time tonight, and I'm so honored to be here to moderate this important public forum, the Independent Court, what it is and why it matters. Our first question is going to go to Judge Davis. Judge Davis, could you briefly remind people about the role of the judicial branch as envisioned in the Constitution?
Thank you, Asia. And let me just express my deep gratitude to the sponsors, both law bar associations, the law school, and Keep Our Republic for putting this forum together. And thank you all for being here. It's so important that people from throughout the community come to hear what we have to say, to question us, and to hopefully learn from us. And we learn from you about your concerns, and in that way we can support our democracy. The courts, of course, at both the state and federal level, constitute the third branch of government. All of you have heard, I'm sure, about the so-called three co-equal branches of government. The two political branches, the legislature and the executive, are political in the sense that they are elected by the people, and while in some states, such as Pennsylvania, judges are also elected at the federal level, we have never had the election of judges. You may recall, in fact, that in the federal system, judges are one, appointed for life, Article 3 judges, appointed for life, or as the Constitution says, on good behavior. And another important ingredient of the judiciary in the American scheme of things is that judges' compensation may not be reduced during their term in office. And these protections were built into the Constitution as a way of ensuring, as much as humanly possible, that the judiciary in the federal system would indeed be and forever be independent and impartial. If you can't influence a judge's pay, and if the judge doesn't have to worry about being removed from office simply for doing the judge's job, that at least gives some assurance that the judge's behavior on the bench, the judge's behavior in deciding the disputes that are brought before the courts will indeed be impartial, based solely on the facts and the law, and that equal justice will be dispensed to all people. So the courts in our system are co-equal to the other two, but as Hamilton said, they are the least dangerous branch. Courts don't have an army, courts don't have a police force, courts achieve their results through reasoned judgment. Every judge in the federal bench at any level has an obligation to you, our constituents, when we make a decision, to give you a decision and explain it fully, to write it in a way that hopefully most people can really understand it. You shouldn't have to be a lawyer to understand what a judge has done and why the judge has done what the judge has done. And then finally, I'll say, in our scheme, the federal courts, the federal judiciary, was intended to be not an anti-majoritarian institution, but a counter-majoritarian institution. And that's important. The political branches, as I say, elected the president somewhat indirectly, but everybody gets to vote for the president. And the districts created for Congress and the statewide elections for U.S. senators gives the people a say in who represents them. And the federal judiciary, to the contrary, is intended to stand between, when it's appropriate, the government and the individual. You all remember the Bill of Rights, that the first 10 amendments to the Constitution, which Madison and other founding fathers thought was imperative that such a Bill of Rights be included in the Constitution. And so that's where the judiciary sits, not above the president, not above Congress, but alongside Congress to keep the balance true between those two branches of government when they disagree about the meaning of the law or of the Constitution, but also to keep the balance true between the individual and government itself. Thank you for the question.
Thank you, Judge Davis. Judge Kugler, questions coming to you next. Why did the framers of the Constitution enshrine an independent judiciary?
Well, they thought, and I think it's still true, that it's important that judges be able to make their decisions without undue influence from what we call the political branches, the legislative and executive branches. And I'd like to use this example to illustrate what I'm trying to say. That is, if you have a case in court, if you're a litigant in court, how do you want your case decided? Do you want your case decided based on who you voted for in the last election? Do you want your case decided on who you've given your political contributions to? No, you don't want that. People don't want that. They want their decisions from their judges based solely on application of the law and nothing else. And that's why it's important. It's important because we need public support. As Judge Davis mentioned, we don't have an army or navy. We don't have a police force. What we have is you. We depend upon you to give credence to our decisions and to enforce our decisions. We depend upon you, the people, to make us legitimate. That's why we need an independent judiciary.
Thank you, Judge Kugler. Judge Ledwater, what is judicial independence and why should everyday Americans care?
Well, as you have just heard, the independence of the judiciary means that judges can make decisions without fear or favor. They can follow the law and do what's right, and that's their only charge, and that's the only thing they have to do. Sometimes we don't like the law that the legislature has given us, but we have to follow it, and we have to follow the precedents, and that's our charter. So it's important that a judge be able to do that very thing without worrying about reprisals. In fact, in Federalist Paper 78, Hamilton talked about that very thing, that judges needed to be independent in order to be protected from influence by the legislative or executive branches, and also to be able to protect the rights of the citizens from overreaching by the executive or the legislative branches. And ordinary Americans should care for a number of reasons, one of which is if judges are feeling threatened or overborne by criticism from the other branches of government or from crazy people who might burn down their houses, as happened to a judge just last night. Two things can happen. One is that those judges, if they're not strong, could cave into pressure and not operate in the independent way that judges are supposed to do. But the most, I think, dangerous thing about that is that qualified people who would be good judges won't become judges. They will shy away from it because they don't want to put their families at risk. They don't want to put up to it. And that's why citizens should care, because your rights are being vouchsafed by the courts, and you should want the judges to be independent so they can follow the law and issue decisions without fear or favor.
Thank you, Judge Ledbetter, and I'm so sorry for mispronouncing your name earlier.
You can call me anything you want.
No, I cannot.
I have a microphone here that says I am Goose One. So, what you called me was much better than Goose.
We actually went over this earlier where I apologized to all of them because I was like, I can butcher a name without even trying. It's so bad. But thank you all so much for your patience. Judge Davis, how does that play into how judges come to their ultimate decisions?
Well, judges come to the ultimate decision, I dare say, really, with very few exceptions, if any, in exactly the same way. First and foremost, of course, courts exist to resolve disputes. And we need a mechanism to resolve disputes, whether we're talking about a commercial dispute between merchants, whether we're talking about a tort claim where there's an automobile accident, or where someone claims that their employer or their school has somehow gone too far in regulating their behavior in light of the restraints on government. And so what we need are judges who are able and willing to, number one, collect, with the assistance of the lawyers, the facts that are relevant to the dispute. And then every judge, once the facts are established, sometimes by a jury, of course, we have a jury trial, right? But the judge's job is to apply the law to the facts. Judges sometimes don't like the laws that judges are required to apply, whether it's criminal laws or civil laws. Judges might think, I don't think this is a particularly just law, or I don't think this is a particularly just outcome. And what judges do when they have those feelings is put those feelings aside, because it's not the judge's role anywhere to decide what the law is. That's the legislature's role. That's the executive's role. Now, there can be disagreement between judges, among judges, about how to interpret a law. And part of the brilliance, the genius of our system is that we have 3 tiers, sometimes 4 tiers, of courts. And so the outcome in a case is the product of a judge's good faith, honest effort to identify the proper facts, apply the law to those facts, and render a decision that is consistent with the law. And the losing party, in the first instance in our system, has an automatic right to an appeal. And by the way, I might mention, the Constitution says a lot of different things, but the Constitution does not give anybody a right to an appeal. There is no constitutional right to an appeal in either civil cases or criminal cases. I'm sorry if I'm sounding like a law professor, but I used to be one. And what has happened is that the Congress and the federal system and state legislatures have understood, again, the genius in independent courts is the fact that a judge makes a decision and then other judges at the higher level in the hierarchy reviews what that judge has done. So anyone who is dissatisfied in this country with a decision by a single judge at the trial court level or by a jury at the trial court level has an automatic right under statutory law to seek further review of that matter. And then, of course, we have in all our systems, state systems and the federal system, a Supreme Court, which is the ultimate arbiter of the law. And so that's how judges decide cases. And that is the work product of judges, a reasoned decision explained, most often in writing, but sometimes orally from the bench, but it's written down. Judges have an obligation to explain their reasons for deciding the way they did, and then there's an ability for further review of that matter by appellate courts.
Judge Davis, it's okay if you sound like a law professor because we're at the Widener Law School. Judge Davis and Judge Kugler, you two have helped to form a group of former federal judges called the Article 3 Coalition. Could you two explain that coalition and why it was formed?
I'll start if you want.
Please.
It was formed because judges who are sitting on the bench currently are prohibited from commenting on any pending litigation in the country. It's in the Code of Judicial Conduct. They can't speak. They can't defend themselves. So we're retired judges. We don't have that prohibition. So we all joined together and said, hey, something needs to be said here about what's going on. Something needs to be said here about the threats that judges are facing. Something needs to be said here and now about the threat to judicial independence. That's what we're doing. That's what we're trying to do with these programs that we're putting on throughout the country, where we talk to our citizens, we talk to our bar associations. We need your help. You have a role in this. Every time you see a judge unfairly attacked, and I'm talking about criticism, we're all used to criticism. Look, every time when I was a trial judge, someone took an appeal from one of my decisions, that's an implied criticism of what I did. That's fine. That's the way it works. That's why we have appeals. But when you're doxing judges, when you're sending pizzas to their home in the name of the murdered son of a judge from New Jersey, you've crossed the line. Somebody needs to take a stand. Bar associations, when their judges are attacked, need to say, enough. We can't do this. This is intolerable. We have to speak up and put an end to this. We have to put an end to the fiery rhetoric that's out there, the rogue judge, the extreme right-wing judge, the extreme left-wing judge, all that stuff that you've heard. is not constructive. In fact, it's very destructive. See, like I've been telling you, we rely on public support, in the judiciary. And what these attacks are doing, if you look at the polls that are out there, it's having an effect on people's perceptions of the judiciary. We need to fight back. We need people to understand how important this independent judiciary is to your lives. You know, you might think, well, federal courts, what have I got to do with that? You'd be amazed at how what federal judges do touches upon your lives and the lives of your members of your family. So it is important. And that's why we've gathered together, and that's why we're doing what we're doing.
And we hope we have credibility, and we hope that the fact that we are judges appointed by presidents from both parties over more than 40 years, all speaking with one voice, will enhance the credibility that the message we bring to you, our constituents, the people we serve. We hope that you will listen to us and give credence to the imperative message that we are sounding, and that is, judges, the judiciary, are critical to our constitutional structure.
Judge Ledbetter.
Yes.
Hello.
Oh,
Okay.
okay. If you're asking about speaking out, I am still a sitting judge, so I can't speak in any way politically, or I'm much more limited by the rules of ethics from what I can say because I'm still sitting as a judge. But I can say that judicial independence is critical, and that it is important for not just bar associations, but all citizens to understand that judges are working hard to do what's right and to follow the law, even if they don't like it. And people can say, or someone can say, oh, that's a terrible decision. I don't like that result. Well, maybe the judge that wrote that result doesn't like it either. But if the statute requires it, we have to impose it. And so that's why it's important for not just bar associations, but all citizens to speak out. If you hear someone saying, oh, that judge is just, well, I won't use an epithet, but, they may not even like it themselves, but they have to do what's right. Yeah.
Thank you. Judge Davis, why are retired judges speaking out now?
As Judge Ledbetter just said, the Code of Ethics truly constrain what sitting judges can do and say. Judges who are in active service speak through their opinions, and their opinions are limited of necessity to the facts and the law relevant to the case. And all the noise out here, the fiery rhetoric, the inappropriate and dangerous rhetoric, calling judges names, calling judges lunatics, saying judges were deciding a case because the judge liked this person or this party or this issue. That is dangerous language. And so we need retired judges who are willing to step up and speak out and speak the truth about these matters and say it's never appropriate, for example, to say that a judge, a federal judge, should be impeached. It's the only way you can remove a federal judge from office. As I said, federal judges under Article 3 of the Constitution are appointed for life. But for very powerful, highly elected officials to say that a judge, simply on the basis of the judge's decision, which can be appealed, should be impeached, that's very dangerous. That's very dangerous language. And so we retired judges have the wherewithal, because we are no longer constrained by the code of judicial ethics. We can speak out and we can say, no, that's wrong. That's inappropriate. And that's dangerous when you attack judges in that way. And by the way, you know, judicial independence doesn't mean, has never meant, as Judge Kugler mentioned, that judges weren't open to criticism and their decisions aren't open to criticism. Of course they are. From the man or woman in the street to the most brilliant law professor, yes, you can criticize a judge's decision or opinion, but not in personal terms, not using dangerous, fiery language. It's not appropriate. So, as I said before, you know, judicial independence is a two-sided coin. On the one side is judicial independence. That's how I look at it. On the other side is judicial accountability. And there are a number of different ways that judges are held accountable. One, I've already mentioned, is by the obligation to issue a reasoned opinion, to show your work, as they say, to tell everybody how and why you decided as you did. And a second leg of that accountability stool, of course, is through the process of appeal. And then the third leg of that stool is the legislature can change the law. Now, the legislature can't change the Constitution. That takes a lot more work. But if a judge or a series of judges have rendered decision on a statute that the legislature that enacted the statute thinks the judge got it wrong, and by the way, the Supreme Court says this all the time when they interpret statutes. They say, if we're wrong about this, we invite Congress to fix what we've done. And in fact, on a number of occasions, Congress has done exactly that. So it's important that judicial independence and impartiality be understood in the proper context.
Thank you. And Judge Kugler would like to add to your point.
I would, thank you. That's a great question. Why now? I can just tell you my own experience. You know, there's a long history in this country of criticizing judges. You go back to President Andrew Jackson, who's purported to have said about a Supreme Court decision, well, they decided, now let them enforce it. And of course, you have President Franklin Roosevelt, who was at war with the Supreme Court. He wanted to pack the court. I'm old enough to remember they impeached Earl Warren billboards that went up as a result of some of the decisions that Supreme Court made. But that's all fine and good. What I perceive to be different now, recently, is the threats of physical harm to judges and their families. I know some of these judges. They're friends of mine. I know what they're going through. I had the misfortune as a judge of having been threatened a number of times and having to live with the U.S. Marshal's protective details following me around for months and months. There's nothing pleasant about that. And if you look at the statistics from the United States Marshal Service, whose job it is to protect federal judges, the number of threats have risen exponentially in the last couple of years. That has to stop. And if I can help, just by speaking out, trust me, and my wife's here, she'll tell you, I'm a very quiet person normally. But if I can help by speaking out on these issues, I will do that. It's that important to me. That's why now.
Judge Kugler, can I ask you a question?
Sure.
When you receive those threats, because outside of you being a judge and this is what you do, you're also a person with a family and a wife. How does that impact you in your personal and everyday life?
Look, we're a human. It affects you. You don't want to look over your shoulder all the time. You don't want to be followed around by these, marshals who are protecting you. But when you became a judge, when we all became judges, we promised we would decide our cases without fear or favor. So you keep going, you keep working, you keep doing the job that you took an oath to do. You keep doing your best to neutrally apply the laws of the nation to these cases. And I think that's what all the judges are doing, those who have been threatened. We have two judges, Joan Lefkoe in Chicago, and Esther Salas in New Jersey, who have suffered terrible tragedies. Judge Lefkoe's mother and husband were murdered by someone waiting in her home for her. Judge Salas's son was murdered, and her husband grievously wounded by a guy waiting for her. They continue to work to this day, because that's what judges do. That's what they do. They serve the public. They serve their constituents to the best of their ability.
Yep. Okay, you're looking at me? Okay.
Well, I didn't know if you wanted to say something.
Well, yeah. These incidents that we hear about that make the news are anecdotal. But I'll give you some statistics about how real this is. The Administrative Office of Pennsylvania Courts compiled statistics on incidents. And I'm not going to go through all the different kinds of incidents, but in 2024, incidents involving assaults were 14 in the common pleas courts, 8 in the magisterial district judges. Incidents involving bomb threats, there were 14. Incidents involving computer crimes, slightly less, there's just 7. Incidents involving harassment, 43 at the common pleas level and 31 at the magisterial district justice level. Incidents involving obstruction of government functions, 37 in the common pleas courts and 49 in the magisterial district courts. And incidents involving terroristic threats, 120 in the common pleas courts and 100 in the magisterial district judges. These threats are real. And as the other judges have said, the judges keep on going, but eventually people get worn down. And I fear that we will lose good judges not because they're afraid for themselves. I'm not afraid to walk around in Philadelphia. I'm not afraid for myself, but we all worry about our families, especially the judges who have small children or grandchildren living at home. It's a weight on people every day. And I fear we'll lose good judges over it.
Judge Davis, could you explore the concept of judicial overreach as has sometimes been put forth by the executive branch?
I think I heard the question. Judicial overreach. There have been instances, to be sure, where judges have gone, shall we say, beyond reasonable bounds in a particular case to decide issues, say, that were not properly presented to the judge. And judges are humans and they make mistakes. But I'm not aware, and I follow current events pretty closely, not just since I became a member of Article 3 Coalition, but I've just maintained an interest in how the courts were doing, even though I retired from the bench 8 years ago. And I'm not aware in the current climate this year of a judge overreaching in any way. What I have observed among the federal judiciary this year, what I have observed is a cohort of hardworking, dedicated federal judges, appointed, talking now about trial judges primarily, appointed by presidents of both parties who get up in the morning and go to their courthouses and undertake to do the people's work and decide cases and controversies, which is what the Constitution says judges are supposed to do. And a lot of the cases this year have involved what I refer to as wait a minute decisions. So many of these cases have involved the aggressive assertion, which is perfectly appropriate if the executive branch wishes to proceed aggressively to implement a policy or enforce a law. The executive branch unquestionably is entitled to do that. But the executive branch and no litigant is entitled to steamroll a judge. And a judge, to do the judge's work, needs the time and opportunity to review the matter that is under consideration, to hear from the lawyers, and with the assistance of the judge's law clerks and with the assistance of the lawyers involved in the case, to reach a reasoned decision. So I'm not aware of any overreaching by the federal bench this year. The federal bench has issued a number of, as I call them, wait a minute orders. These temporary orders, sometimes they last for 10 days, sometimes they last for 14 days, and on occasion it's an actual preliminary injunction that stays in place until the case is fully heard. All of that is very routine, not just in the federal courts, but in state courts. What's different this year is simply just the tsunami of cases that have been filed in response to some of this aggressive policy implementation. Again, which is no criticism for me about that, but judges and courts are entitled to have a full opportunity to consider the matters in a mature and reasoned process. And if you've been following some of these cases, you know that in most of the instances in which the federal trial judges have issued these wait a minute orders, which don't decide the case at all. They simply maintain the status quo that existed before the case started, so that the judge has a full opportunity to consider what is before the judge. In most of those instances, I don't have specific statistics, but in most of those instances, the appellate process, the appellate courts have left those orders in place. They've left them in place, which again is a part of the normal process. Now, the Supreme Court, to the contrary, in many of those cases, has said, oh no. They've ruled contrary to the preliminary decisions of both the trial level judges in the federal system, and the courts of appeal. That's the Supreme Court's prerogative. That's their job if they think that's the right outcome. The problem with that is, in part, the perception that is now created when the Supreme Court of the United States issues one of these unexplained orders. When you have two lower courts ruling one way, often on the basis of an actual trial. There have been a few of these wait a minute orders that have been issued after an actual trial in front of a trial judge. So when you have the Supreme Court reversing decisions of the two lower federal courts without explaining why on the so-called shadow docket, I'm afraid that creates a perception coupled with the rhetoric that some elected officials are using. It creates an environment where people who are not tutored in the law may have a perception that it's the Supreme Court and the executive branch against all these other judges. And that's wrong. You never want to create that perception. You never want to create an environment an ethos in America in which people are left to think these lower court judges are just gone crazy. Maybe they are lunatics because the Supreme Court keeps doing this. And so I don't think there's been any overreaching. I think that the Supreme Court has carried out its responsibilities in the way that it has chosen to carry them out. But coupled with the rhetoric and coupled with, frankly, many of the false statements, not just rhetoric, but there are false statements about the law, about the Constitution, and about what judges do and have done that have created this atmosphere of fear and danger that we've talked about. And one of the fears here is that you all, the public, we the people, will lose confidence in your judiciary. And my goodness, if and when that happens, we will really be in big trouble. Because your confidence in the judiciary is the coin of the realm. As we've said, courts don't have an army, courts don't have a police force. Courts rely on, for their legitimacy, on the acceptance of we the people, you the people, that the courts are operating in a manner that is appropriate and in the best interest of the country. So that's a long-winded answer. No, there hasn't been any overreach this year that I've seen.
Judge Ledbetter, what do you wish that everyone knew about judges and their role in preserving liberty and equality?
Well, I think we've covered a good deal of that already. One of the things that I will point out is that I'm on an appellate court, that appellate courts have to accept almost 100% of the time the fact findings by the trial courts or the jury. That means if the trial judge says, I believe this particular witness, and so I rule in that witness's favor, I think that person deserves to win, we check that ruling for whether it satisfies the law. But what we can't do is say, well, I don't think he was right about that witness. I think that witness was lying. And I shouldn't say very often, but with some frequency, appellate judges are faced with a trial verdict or a decision of the lower courts in which we say, well, I wouldn't have found it that way, but we're bound by it. And so, but because we have to. I also want to point out that the court that I sit on is really the people's court in that almost all of our cases, it's a citizen on one side and a state or local government on the other side. So we have to be aware of, if we were prone to just do whatever the government wanted us to do, the citizens would have no rights at all. We have to stand as the bulwark between the citizens and the state government or the local governments when they are, and sometimes the local governments or the state government will engage in overreaching. They will ask us to do things that really are not in compliance with the statute. Sometimes our agencies will try to do things and we'll say, no, the statute doesn't allow you to do that. That's our job. And so that may make the government unhappy and they may say, oh, those judges are, they're overreaching. Well, we're not overreaching if we hold the government entities to their lawful roles. And I know you asked me what kinds of thoughts I had. There's probably lots others, but that's my answer for now.
Yes, and Judge Kugler would like to add to that too.
Yes, thank you. One thing I would hope people take away from sessions like this is how difficult these cases are. Judge Davis referred to them as a tsunami of litigation, and it really is. It's unprecedented in the history of this country. And I'm not criticizing the administration for, doing what it's doing, but it puts the judiciary in a very difficult spot because there is no precedent for some of these cases. These issues have never been litigated before. The judges are doing their best. They're agonizing over these cases and these decisions. Surely, just as a matter of statistics, some of these judges' decisions will be reversed. They already have been at the Supreme Court. They're wrong. But we're human. We make mistakes. We can't be expected to get them all right all the time. But that's no excuse for calling judges names and threatening their lives. It's a difficult job. Judges are trying very hard, and they need your support.
So we're now going to take questions from all of you, the audience. So for our first question, how do we reconcile a desire for judicial independence and safety for judges in our country with an equally important desire for accountability, civil public discourse, and review of judges' personal and professional conduct?
Well, there are all kinds of mechanisms in place to enforce those kinds of things. I mean, the first is the appellate mechanism, as Judge Davis talked about. Judge makes a mistake, you have a right to appeal it. Go to a higher court and try to get it reversed. That's accountability. Judges have to file financial disclosure statements every year. They're public records. You could see whatever financial holdings a judge has. There are mechanisms in place to discipline judges who violate parts of the Code of Judicial Conduct. So there's all kinds of accountability built into the system as it presently exists.
Yeah.
That's exactly right. Go ahead, Judge.
Yeah, no, well, I was just going to say in Pennsylvania, we have not only the canons of ethics, which I think just about every state in the federal government have, but we have a conduct board who takes complaints from any citizen can file a complaint with the conduct board and they will investigate it. Sometimes they're crazy frivolous and sometimes they're meritorious. But the conduct board will consider these things, they'll do an investigation, and they will sometimes bring charges. And then we have a court of judicial discipline that will actually hear the cases that the conduct board brings and decide whether it's an offense against the ethics or not, and impose penalties up to and including taking away someone's law license if they're a lawyer. So, and with a judge to take them off the bench. So there are many ways that we have, as you heard, accountability through the appellate process, but also through the ethics procedures that hold judges to good behavior, because we're all taking oath to behave ourselves. I think that's the exact words in the oath. And there are mechanisms if we do not.
And I would simply add, I know I speak for Judge Kugler and myself, but I think I speak for virtually every trial judge in the federal system. Not only do we not mind having our decisions reviewed by appellate judges, but we actually wouldn't want to be in a system where our decisions were not reviewed by other judges through an orderly appeals process. So the accountability that comes from having our work reviewed, our homework is reviewed by the higher court, and we embrace that. We don't always agree with what they decided, but we want them there because we are all human and none of us is perfect.
Thank you. In what instance does it make sense for a judge to delay the admission of a plea by a defendant when doing so could potentially place the victim in harm's way?
Well, that's a tough one. That really gets into, the judicial craft. And there are instances in which the parties in a case, the prosecutor and the defense lawyers reach an agreement about what the proper disposition of the case should be. But in every system that I'm aware of, state and federal, the judge is the final arbiter of whether a guilty plea in a criminal case will be accepted. No one can force a judge to accept a guilty plea from a defendant. And it involves a whole host of issues, of course, which we don't have the time to go into tonight. But having been a prosecutor earlier in my career, I know that by and large, prosecutors care deeply about victims, particularly of violent crimes. And so the judge is called on sometimes because a prosecutor, for good reasons, may want the judge to accept a particular guilty plea, a plea agreement, and the victim may be opposed to that plea agreement. And it's part of what makes the work so interesting and so challenging.
Sometimes there's just a bigger picture than seems evident at the beginning of these cases. And the public is not always advised of what the bigger picture is for a lot of good operational reasons for the government, things of that nature. But I can assure you that any instance in which a judge is faced with a victim who's opposed to a particular plea offer, the judge gives careful consideration to what that victim has to say. I know my own practice as a judge, I would require the government to set forth sufficient reasons why I should accept this plea. I'd require the defense counsel to also tell me why I should accept this plea. Now, sometimes those reasons had to remain secret because, again, sometimes there's a bigger picture. There are bigger things going on out there than just this one case.
What are your thoughts on the federal government frequently contesting rulings that run contrary to its policy agenda or administrative goals?
Well, as Judge Davis alluded to before, I don't think we have any objection to the administration taking these aggressive stances. I mean, this goes back really to the founding of the country and the way the Constitution is set up with the three branches of government. And one of the things that becomes obvious is what they call separation of powers. There's always been this tension between and among the three branches of government. The only thing different now, I think, as Judge Davis said, is this tsunami of litigation. It is unprecedented, the amount of litigation that's pending and has been filed about the actions of the executive branch. But I don't think any of us who are judges begrudge the executive branch from trying to stake out what it believes are the limits to its power. It'll all get straightened out, primarily through the courts, and the Supreme Court eventually.
The executive branch has a right to appeal just like every other litigant. And I'm not aware of any judge who would begrudge that.
No.
What can the public of courts do if a branch of government ignore a ruling?
Well, courts
There's
have
contempt power.
contempt power, exactly. You can hold contemnor, the person who's disobeying the court order, in contempt. And the penalties of contempt can range from fines all the way up to incarceration, imprisonment. It's a power that I don't think judges like to wield because it is punitive, but it is available in the right circumstance.
I think the question was, what can the public do? Did I hear that right?
Yes. What could the public or courts do?
Or court. Okay, yeah. So what can the public do, Judge? Well, the public can speak out, speak up in your community organizations, in your homeowners associations, in your synagogue, in your church, in your schools. You can talk to your neighbors and friends and family and help educate people about the importance of the judiciary. You can question your elected officials. You can demand accountability from them. And you can insist that they explain, if it ever happens, how it could be that they willfully disobeyed a court. And you can tell them you don't like it, because you shouldn't. That's why we have appellate courts.
Right, right. I think, as I said, in most of our appeals, a government entity is on one side or the other. And generally speaking, and certainly when I was with the government, with the U.S. Attorney's Office, our credibility was very important to us. Agencies tend to want to have credibility so that when they ask for something, they're more likely to get it. And so one thing we can do if an agency, and I did this recently in a particular opinion, has played fast and loose, we can say we don't appreciate that kind of behavior. And, here's the ruling, but even if you've won, you have behaved badly, and I think that does have an effect on any repeat litigant, whether it's a government entity or a corporation that has a lot of litigation. If you let them know that their credibility is being undermined by the way they're behaving, it can have some beneficial effect.
Would you speak about the influence of huge amounts of money coming into this election, using it to dismantle dis and misinformation?
I don't think we in the federal courts have much experience with money because we don't run for office. So we're not raising funds for political campaigns. I think maybe Judge Ledbetter would know more about that because in Pennsylvania they do elect judges, correct?
We do. I think we get good judges from an appointive system as well as from an elective system, as we have in Pennsylvania. But I think the fact that in order to run for office, and in Pennsylvania you have to run for the first time in a partisan election, a Republican versus a Democrat, the money is insidious in that people who want to become judges shouldn't be collecting money from interest groups because other than your family, nobody's going to give you money, or rarely do people give you money just because they like you or think you're a good person. Generally, the people who want to give money to candidates are people who think it's going to be in their interest in one way or another. And worse than that is, I think, the public perception. When you read in the paper, and as I think Judge Davis pointed out, candidates, like judges, have to file financial statements of every person who's given them money, every entity that's given them money. And when you read that a candidate for the judiciary has been given $1 million or hundreds of thousands of dollars or even tens of thousands of dollars by a particular group or person, it undermines confidence, I think, in the judiciary, because I think the money is very very bad. That's what I think is worse about the system of electing judges.
In recent years, district court judges have issued nationwide injunctions in what seems like an exponential growth of it occurring. Many in the public see it as the judiciary attempting to hobble the president's agenda. Many of these end up in the Supreme Court and get overturned. Should district court judges be allowed to issue nationwide injunctions, and why?
I just did a program on Bloomberg Law on this very subject, and the bottom line is there will not be any more, or there'll be very few, what they call nationwide or universal injunctions. They just aren't going to happen. The Supreme Court's made that very clear in the CASA case. So it's not an issue I think people need to be worried about. The circumstances under which a nationwide class action can be issued will probably occur in very limited number of class action cases and maybe some Section 702 attacks on administrative regulations. But those days are over, folks.
Have any of the panelists published, edited, or co-authored a book available at my local library?
I'm working on one. I'll get back to you.
No.
No.
Since federal judges are selected versus elected, who, in your opinion, are their constituents? Are they really accountable?
Well, I think we've certainly tried to answer that, and I would say yes, we are accountable in the ways that we've described. And by the way, to become an Article III judge in this country has been, I think, been accurately described, though colloquially described, as an autopsy on a living person. By and large, the FBI is quite thorough in their investigation. Of course, the senators of the home state of the proposed judge who's going to be nominated play a significant role in who even gets investigated by the FBI. And so it is a very rigorous process, not perfect. Certainly, no human endeavor is perfect, but it is a thorough process that is, by the way, political. There's no question about it. Presidents, and it seems to me entirely appropriately, select people they want to appoint to the federal bench who they perceive as having views or philosophies that align with the president's preferences. Nothing wrong with that, and it's never going to be any different. So it is a political process that leads to the nomination of a judge. What I think we at the Article III Coalition try our best to persuade you, the people, is that once that nomination makes its way through the United States Senate and the president signs that commission, politics ends. And that's what the Chief Justice said in his annual report last year or the year before. He said there are no Democrat judges in the federal judiciary. There are no Republican judges in the United States judiciary. And I believe that to be true. And that's what Article III Coalition is trying again to get across, that we are United States judges. That's what we are.
I think it's a great question because it really vividly illustrates that fault line between accountability and independence. How do you straddle that line? And we've talked a little bit about the mechanisms that are available to discipline judges when they stray from the strict ethical line they're supposed to take. But you don't want, in order to preserve judicial independence, you don't want to make it, I think, and maybe I'm saying this because I was a judge for so many years, you don't want to make it easy to remove the judge because you disagree with his or her decisions. And that's the whole debate about impeachment of judges because of their decisions. And I was heartened back in February when the Chief Justice came out with that very strong statement, when there was a lot of talk in Congress about impeaching judges because of these injunctions they were issuing. And he pointed out that in that long, proud history of this country, we don't do that. We don't impeach judges because we disagree with their decisions. And I think what he said has put an end to that sentiment in Congress. So that is a debate that will go on forever between independence and accountability. And that's really something that you can be involved in, you the people. You can be heard on these issues. You can influence the kind of legislation that's passed that requires judges to reveal their financial details. It requires judges to do certain things. It's something that you can be heard on if you want to.
This question is from our youngest audience member here. What are some rules of being judges and why are they so strict?
Because people demand accountability.
Yeah.
And that's appropriate.
I think the best quality a judge can have is patience. You've got to be able to listen to everybody and listen to what they have to say. You've got to give everybody a voice. I mean, they are our constituents. They really are. It is the people who appear before us that make us legitimate, who we count on to honor our decisions and our orders. So you have to hear them out. Patience, I think, is the best virtue a judge can have.
Yes.
What are your thoughts on reports of immigration judges being reassigned, pressured to retire, or removed from their positions, and how do such actions affect judicial independence within the immigration court system?
Well, the first thing to point out is the immigration judges are not appointed pursuant to Article 3 of the Constitution. They are not part of the federal judiciary. They are an executive branch agency. So the rules that govern us, who have been appointed pursuant to Article 3, really don't apply to them. And other than that, I really don't have an opinion on what's going on in the immigration courts.
I don't think I can add anything to that.
Nor I.
Does it make sense to have limits on length of time served, for example, 12 years, 15 years, etc., or someone that goes away for a lifetime? How would this be accomplished?
Well, in Pennsylvania, judges serve for 10-year terms. And after being elected in a partisan election the first time, after 10 years, you can stand for retention, and it's just a yes/no vote of the people on the ballot. Now, that provision came into being in Pennsylvania with the Constitutional Convention of 1967 and 68, and the proponents of that provision, that we would have retention, nonpartisan retention elections, believed that it was going to be very nonpartisan. And they said, I'll give you a quote from one of the delegates. The election contemplated, this is the standing for retention, does not follow the usual type of political campaign, since the judge who seeks to be retained for a regular term runs on his own record. He does not have to spend the time, physical and mental energy, nor the money required by a typical partisan competitive campaign. His only investment in effort and money to be retained is in the work he has put into his judicial duties to gain a satisfactory record and in the cost of a postage stamp used to notify the election officials that he desires to be retained for another term. Well, if you've been reading the papers, you know that their thoughts about this were as wrong as their constant use of the male gender in describing judges, because, well, we have more women on our appellate courts now than men, and hopefully that's because the voters have confidence in us.
You may be interested to know that floating around out there for a while now has been this idea that with regard to the United States Supreme Court, there are those who believe it would be a good idea to have fixed terms. Mostly people talk about 18 years, and to structure it in a way so that every president elected to at least one term would have the opportunity to appoint at least one and maybe two Supreme Court justices. Now, who knows where that's going to go, but it would take an actual amendment to the Constitution to abrogate a lifetime appointment to an Article III judge. But that idea has been studied and discussed, and I might say it's been discussed on both sides of the aisle, as they say, in the political branches.
As judges are elected in Pennsylvania, is our judicial branch the third political branch?
Well, all government is essentially political. I mean, it's government, and it's the third branch, and I don't think that has anything to do with the fact that we have been elected, other than those who have been appointed and just served a year or two. It's just that all government is part of the body politic.
How can we work towards turning down the temperature of contemporary discourse when the rhetoric from the U.S. Supreme Court has become increasingly hostile?
Well, that's someone's paying attention to what the justices are writing in their concurrences, that's for sure. You know, there's always been that back and forth on the Supreme Court. Justice Scalia was famous for having a sharp tongue in his dissents, which were dissents and now have become the majority opinions in a lot of instances. I think people need to speak out. They need to, I mean, you have an effect on your political leaders. They're running for office in your communities. You can say to them, look, lower the rhetoric about these judges. We don't need that. Because it's really coming from both sides of the aisle. It has been historically. So you can have an effect with the elected leaders in your communities and your states by telling them that this is unacceptable behavior and you have to quiet things down. It's got to start with somebody. I'm not know that the Supreme Court is going to start it, but it has to start with somebody. And I think if we start with our political leaders, our community leaders, we'll make progress there.
I agree. All of you have a voice, and I would urge you to use your voice to communicate to elected leaders and appointed leaders that you don't like the incivility, you don't like the disrespect. We can disagree without being disagreeable, and that's what you want.
Right.
That's what you want.
Yeah. Could I clarify what I just said a minute ago? When you asked about whether we were a political branch, okay? And I said all government is essentially part of the body politic. I did not mean that the courts act in a political sense, in a partisan way. That is absolutely not true. When I went on the Commonwealth Court, I did not know what to expect, but I was thrilled to discover when I got on the court that none of my colleagues acted in any kind of a partisan political way. Every judge has been just trying to do the right thing and follow the law, and I have never seen any hint of politics on the court that I'm on, nor do I see it in the other courts in Pennsylvania. Even though we're elected to the bench and we have to engage in partisan politics to get elected, we don't act politically in that way. And if I said something that suggested to the contrary before, I did not mean to do that.
Judge Davis stressed reasoned opinions. How does the Supreme Court's increasingly use of emergency shadow docket undermine these efforts?
By not issuing reasoned opinions. That's a very problematic practice. I think most of us observers hope they will cut it out, but they make their own rules and they follow what they think is right. It's, to a certain extent, a product of what I use the term tsunami of litigation. But it does, I think it's corrosive of our respect for the rule of law to have the highest court in the nation issuing these one-sentence decisions without an explanation. And I hope we'll see less of it.
Yeah.
That's what I hope.
It leaves the lower courts not knowing what to do, not knowing really where they went wrong if they've reversed.
That's so true.
Yeah.
So true. Because remember, the lower courts, they're looking at the Constitution and they're looking at statutes, but they're also looking at what the Supreme Court has already decided. The precedents are every bit as important to a trial judge or an appellate judge, for that matter. The Supreme Court's precedents are just as important as the words of the Constitution or the words of a statute. And that's what the lower courts really are trying to do. And so there's no question that this Supreme Court in the last 9 months have actually overruled a couple of their decisions on the shadow docket. And we will get the explanations in some of the cases that are actually being argued this term. But they've actually overruled some of their precedents. And is that any way to run a railroad?
There's a district judge in Massachusetts who wrote an opinion back in August in one of those universal injunction cases. And in one of her footnotes, that was her point. She was addressing Justice Gorsuch's concurrence, which was highly critical of the district court in that case before the Supreme Court on the shadow docket. And she's essentially, and I'll paraphrase her, she's saying, look, we're doing the best we can. We're not getting any help from you folks on the Supreme Court. We don't know what it is you want us to do because we're getting one-sentence orders and not opinions. Now, the only saving grace, I think, here is that many of those cases will be back on the Supreme Court docket this term or next term, and then we will finally get reasoned opinions which will help guide the lower courts. I can just tell you my frustration, and I wasn't part of any of these universal injunctions. I left the bench last summer before all this started. But the frustration that we as trial judges felt constantly was trying to figure out what it is that the higher courts wanted us to do in some of these cases, because they just were not issuing well-reasoned opinions to guide us. But hopefully a lot of that will be resolved in this term and next term from the Supreme Court, hopefully.
I wanted to take a moment here to just really thank all of you for coming this evening. Again, to thank our sponsors, Keep Our Republic, the Dauphin County Bar Association, the Pennsylvania Bar Association and Foundation, and Widener Law Commonwealth. To our moderator, Ejitav, you did a fabulous job at helping us have this conversation. And our panelists, Judge Kugler, Judge Davis, and Judge Ledbetter, for what a wonderful discussion here this evening. I'd like to thank PCN, who is here recording this, so that this dialogue can be taken out and shown across the Commonwealth. And to you, our outstanding audience, and your fabulous questions. I know we didn't get to all of them. I think the judges will hang around for a few minutes if you really want to know the answer and are dying to know them. We did our best, but as 7:30 comes, we don't want to keep you here all evening, although I felt you might have stayed a lot longer. Again, thank you very much. And again, we appreciate it on behalf of the Bar Association.
Pleasure.